May I
Yes.
please, Your Lordship? With the consent of other side, Lordship, I beg to mention item number 11, Lordship. Some personal difficulty to pass over for the day, Lordship. Item number 11.
11.
Yes, sir.
On the prayer of Mr. S.S. Roy, learned
CGC.
CGSC, may trust and adjourn and be listed after a week.
Obliging.
May I please, Your
Lordship, we are,
So for-
we are the petitioner in this case, as per Lordship convenience, if that can be fixed after 2 weeks.
Give a date. Sixth.
May I please, Your Lordship? So for item number 30 is concerned, in this case, Lordship, the Coal India has filed a review petition being 113 of 2023 and is pending disposal, Lordship. Therefore,
Okay.
Lordship, let the review petition be tagged and contempt petition be tagged with the review petition, Lordship.
We're adjourning it on the prayer of the learned counsel for the petitioner. May trust and adjourn and be listed after 2 weeks.
Obliged.
Lordship, I beg to mention item number 12. Lordship, the client has instructed me to withdraw the said case.
Okay, you are Mr.
B. Gogoi.
D. Gogoi. B. Gogoi.
Hi.
Mr. B. Gogoi, learned counsel for the petitioner, submits that he may be submits that he has instruction from his client to withdraw the present petition. Accordingly, praise for the same. Prayer is allowed. This writ petition, accordingly, this writ petition stands closed on withdrawal.
May I please, Your Lordship? I said to mention item number 19, my lord.
19.
19, my lord.
Yes.
May I pray for adjournment, my lord? Mr. Airway is out of station on medical reason, my lord.
On the prayer of the learned counsel for the petitioner, may trust and adjourn and be listed after 2 weeks.
Obliged.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 22 of today's daily list. Lordship, we have received instructions for this case. We'll be filing our affidavit.
U.S. Finance,
Lordship, health in this case,
Health.
Lordship.
the learned standing counsel for the health submits that he has received instruction and will require 2 weeks time to file affidavit. Accordingly, praise for an adjournment. Prayer is allowed. List this matter after 2 weeks.
May I please, my lord, I beg to mention item number 18, madam.
18.
18, madam. Sometime may be granted for filing reply affidavit, madam.
Learned counsel for the petitioner prays for and is granted 2 weeks time to file rejoinder affidavit. Reply affidavit.
May it pleases Your Lordship. Lordship, I beg to mention item number 38, Your Lordship.
38.
Lordship, I am making this mention on behalf of Mr. M. Kashyap, Your Lordship, for the respondent, Your Lordship. Lordship, due to ensuing elections, Mr. M. Kashyap is not present, Your Lordship. He is out of
Have you
station.
taken consent from the?
Yes, Your Lordship. Consent is
On the
already-
prayer of the learned counsel for the
38.
respondent, matter stands adjourned and be listed
For Your Lordship's convenience, after 2 weeks, Your Lordship.
after 2 weeks.
May it please your Lordship? I beg to mention one WPC relating to Civil Bench 3 relates with Industrial Dispute Act. So as per the senior bench, it is to be mentioned here, Your Lordship, for orders, Your Lordship.
Next week.
May I present, Lordship? Lordship, I beg to mention item number 43, Lordship.
43.
Lordship, my senior is out of station, Lordship. Password for the day, Lordship.
You have for? A petitioner,
Lordship.
learned counsel for the petitioner prays for an adjournment. Prayer is allowed. List after 2 weeks.
Obliged, Lordship.
I beg to mention item number 15, Lordship.
One
Senior
five. Yes,
is out of station, Lordship, for 14.
you have for petitioner or respondent.
Petitioner, Lordship.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 3 weeks.
Lordship, I beg to mention listing one admission matter next week. One admission matter next week.
For motion item number 1.
I praise your lordship.
Yes.
Lordship, the The contempt matter, Lordship, the order is at page 11, it starts from page 11. Relevant is at page 16, Lordship.
Direction was issued to whom?
Lordship, page 16, paragraph 9. May I read it, Lordship? Consequently, may I read it, Lordship?
Who issued the impugn order earlier?
Lordship, the order was issued by the Principal Chief Conservator Forest.
So you are issuing notice to the respondent number 2.
Lordship, only one issue is there, Lordship. After this, it was communicated, page 80, Lordship, a show cause notice was issued in purported compliance of paragraph 10 of the judgment, that is at page 23. Lordship, against that, we had preferred a writ petition. That the Honorable Single Judge was pleased to dismiss it. Against that order, we had now preferred an appeal, Lordship. The delay has been condoned and the appeal has been fixed for admission hearing after 2 weeks.
There is an option.
Yes,
So orders are set aside.
Lordship.
Have you been given the consequential benefit?
Against
Only that much
Only-
relates.
Lordship.
Yes,
Lordship, they have been asked to just give reasons as to why they will be eligible. And based on the last order, Lordship.
Our submission is that our benefits have been restored. So,
no, two aspects. One aspect is that their demotion or whatsoever reversal was set aside.
Yes.
Okay. Now, with a direction that on consequential benefit be given. With a liberty that if you think that they are not entitled for promotion, issue a notice and proceed accordingly.
Lord.
You have done the second part.
Yes.
Now, what will happen for the period for which you have taken their service in the promotional post?
Lordship, I'll take updated instructions on this regard.
Isn't it?
Lordship.
Even if you are entitled, what will be your response to that? Now, what to do today?
Lordship, it may be taken up after 2 weeks. In the meantime, the appeal
Okay.
is
On the
pending.
prayer
That
of
may-
the learned counsel for the petitioner, matter stands adjourned and be listed after 2 weeks. You have that part, that
Yes.
much only.
Obliged.
My lord.
As per the
Last to.
last court order, we have to produce the gradation list.
In the manual, my lord, I have collected certain documents that my marks were tampered by the husband of the respondent number 8. And those documents we have collected after filing ITA application, and thereby my name was written below the respondent number 8. So,
This is a matter of promotion.
Okay.
He claims promotion. You say he is not entitled. Can we decide on the basis of an instruction? File an affidavit, will issue a notice.
Okay, definitely.
Right.
I will bring it on
they may
record.
be directed to provide a copy of the
They
gradation.
will file an affidavit, that's
Okay.
why.
Lordship,
You
Lordship,
cannot decide a promotion matter on the basis of instruction.
Lordship.
Heard Mr. Mahmood, learned counsel for the petitioner. The petitioner is aggrieved by an action of the respondent, whereby action of the respondent in promoting respondent number 8 to the next higher grade of
Senior assistant.
senior assistant.
Yes.
Senior assistant. Full stop. It is the case of the petitioner that ignoring the seniority of the petitioner, the respondent number 8 has been promoted.
Seniority and merit.
Seniority and merit of the issue notice returnable 4 weeks. Mr. Das accepts notice on behalf of all the respondents, not all.
No,
What 2 or 3?
2 and 3,
Bora for
2 and 3.
2 and 3, Das for
1, 4, 5 and 6.
1, 4, 5 and 6, 7 and 8, both ways. Extra copies, 5 days. Give it to. File a affidavit.
Lordship, Lordship.
May it please the law. The fixing petitioner here before a lawsuits are the Anganwadi workers and one of them.
Third, Mr. Swenson, learned counsel for the petitioner, also Mr. Sutia, learned counsel, also learned additional senior government advocate. The present writ petition is filed by the petitioners who superannuated from service as Anganwadi workers, and they claims and they alleges their deprivation from what do we call it?
Terminal benefits, my lord.
Deprived from
Annexure to-
terminal benefits as per the policy decision of the government. First up, issue notice 4 weeks. So Sutia, except for all extra copies. Yes.
Exercise.
None appears for the petitioner on call list of. Yes, Mr.
My lord, the issue is relating to my lord, the charge on service.
The
In fact,
the
another petition is pending also.
petitioners were discharged from service under Rule 48 of the Central Civil Services within bracket Pensions Rules 1972 on the ground of being in the low medical category within bracket LMC. It is the case of the petitioner that in similar set of facts, this court has taken a decision favorable to the petitioner in WPC earlier decision.
But 1421 of 2017.
1421 of 2017. The petitioner claims a similar benefit. Issue notice returnable 4 weeks. Mr. Gogoi, all? Gogoi accepts all. 5 days extra copies.
All the jobs.
26.
This where is PP? Wait for something. Name reflected.
Yes, yes. It is
Just-
reflected that after motion matter, there is also written.
7.
Yes, what is this?
May I please your lordship, my lord?
Hmm.
Here petitioner was released on the interim bail, my lord. And his statement has been recorded, my lord. He was
Why
re-
this matter is listed here?
I don't know, my lord, earlier also listed, my lord. Because it was never rejected, my lord. So far, it might be.
Yes,
Huh?
Yes, my lord. We also don't know why it was listed.
That is listed, I think, because in one cases I have
Yes.
passed order, two
That is-
cases,
My lord, your lordship made the-
and in other
Ba-
cases, but
Bail has been granted by your lordship.
what is the issue here?
Issue is that, my lord, the petitioner was the, my lord, at that time, my lord, additional deputy commissioner of, my lord, Dhemaji district, my lord.
Mhm.
At that time, my lord, what happened, my lord? A road has been, my lord, surveyed by the authority, my lord, National Highway Authority, my lord. And earlier road was surveyed on different side, my lord.
Case there is there?
Yes. আছে না?
আছে।
Subsequently, it was surveyed on different time. The land of the informant was not taken.
Hmm.
And that is why, my lord, he become, my lord, angry, my lord, filed the FIR. This is the case. Anyway, my lord, it is the, as per, my lord, section 9 and section 10 of the land acquisition
Where is the affair?
FIR, yes, lordship. This is the second FIR, my lord. Earlier, he has filed an FIR, my lord. And
Page
I,
9,
my lord,
I'm taking Utpal Dole.
yes, page 9, my lord. May I read the Assamese version, my lord? That will be.
Why?
I can.
You do not like English or what?
Actually, my lord,
Actually,
I
what?
am comfortable with Assamese language.
Comfortable with this one. Okay, let us read it.
My lord, page 9.
Assamese, page 17.
17, my lord. Ezahar, Mintu Kamal, and Sintu Oika. মহোদয় সন্মানপূৰ্বক দুটা নিবেদন এই যে অসম চৰকাৰৰ অসম মালা অধীনত ঢকুৱাখানা ধেমাজি তেলেং নিৰ্মাণ হৈ থকা পথটোৰ বাবে ভূমি অধিগ্ৰহণ আৰু সম্পত্তি ক্ষয় কৰাৰ বাবে ক্ষতিপূৰণ ধন জালিয়াতি চৰকাৰী বিষয়া দালাল চৰকাৰী মিলি 24 কোটি 15,70,644 কোটি টকা আত্মহত্যা সম্পৰ্কত যোৱা ইংৰাজী 31/7 তাৰিখে আৰক্ষী অসম আৰক্ষীৰ আঞ্চলিক প্ৰধান মহোদয়ক এটা লিখিত অভিযোগ দাখিল কৰিছিল। Earlier he has filed an FIR মাইলত। ইয়াৰ পূৰ্বেও মাননীয় ধেমাজি জিলা উপায়ুক্ত এখন লিখিত অভিযোগ দাখিল কৰিছিল। অসম অভিযোগৰ ভিত্তিত কাৰ্যালয়ৰ এজন উপায়ুক্ত অতিৰিক্ত তদন্ত কৰি আছে বুলি জানিব পাৰিছো। That matters were enquired by the additional deputy. গতিকে দয়ালু মতে আপোনাৰ হস্তগত গোচৰ পঞ্জীয়ন কৰি উক্ত অভিযোগ সন্দৰ্ভত দোষী বিষয়া আৰু কৰ্মচাৰী দালাল চক্ৰ বিষয়গত গ্ৰহণ কৰিবলৈ অনুৰোধ কৰিলে। এই বহতিৰ ওচৰত সৰল প্ৰাৰ্থনা। Then my lord, but first FIR my lord, your lordship, that is not FIR filed before the my lord, the director general, page 19 my lord. আবেদনকারী বিনীত নিবেদন এই যে page 19 এই যে মাস্কো অঞ্চল সমাজত ধেমাজি জিলাৰ ভূমি অধিকাৰৰ ওচৰ স্থাপন বিপদ লিপ্ত হৈ গোপন চৰকাৰী জন কোটি আত্মহত্যা কৰিলে। উক্ত বিষয় ধেমাজি জিলাৰ অতিৰিক্ত উপায় মাই নেম মিছ নেচৰ উৎপল দলে ধেমাজি ৰাজহ চক্ৰ বিষয়ৰ অচ্যুত বৰুৱা কানন্দ প্ৰেম শইকীয়া লাখমন্দ ভোকেশ্বৰ শইকীয়া ধেমাজি সংমণ্ডলৰ পথ সংমণ্ডলৰ বিষয় মাইল that is important my lord because his allegation is that my lord the building has been my lord when the building has been assessed my lord it was wrongly assessed and my lord and Jonaram Dole my lord this is my second bail petition my lord and Nirut Sangmai Dhemaji Gaurapte Griho.
What is the earlier order dispose of?
Yes my lord. Your lordship.
Allegations are serious.
My lord. But whether they are involved, my lord, that is the yes, my lord. And your lordship kindly consider, my lord, my statement has been recorded. I was retired from my service, my lord. And after my retirement, sanction has been made, my lord. And ultimately, my lord, deputy commissioner, my lord. There are several order, my lord. Interim order has made absolute. In my second bail application, my lord, that order also annexed, my lord. Pankaj Mohan here, and bail application has been absolute, my lord. And Lobo Sonwal, my lord. A document of what very important document. And the person who is SS is already enlarged on bail, my lord. This is.
Lobo Sonwal was arrested 439.
Yes, my lord. That's Pankaj Mohan, my lord. Also can go. His name has been mentioned, my lord. He is also my lord. His house has been, my lord.
He was arrested. You want that order?
Yes, my lord. If you also go to the order of the
You
Lobo
go
Sonwal.
inside, then we'll grant you a bail.
My humble submission, he is retired from his service, my lord. After that, it was sanctioned, my lord. Subject to correction of my learned friend, my lord.
We'll see the case diary. What is your involvement?
Yes, my lord, because my lord, the scam of 6.33 crores, my lord. The taxpayers' money has been, my lord, misappropriated.
You know, the abstract of assessment list, my lord. Whether my signature is there. If-
No, we'll see the case diary.
Yes, one
See,
thing-
two aspects of the matter. One is if you have siphon of money making wrong assessment. Two aspects. Your argument is that wrong assessment is a wrong assessment.
Yes, my lord.
But if there is no house and you give a compensation for two-storied house, there may investigation may be required.
My humble submission.
These are allegations.
My humble
So we'll
submission-
see.
My humble submission before it is a general allegation. Your lordship
No,
kindly.
no, it's a specific allegation.
I am coming, my lord. Specific allegation, I have given the abstract copy of the assessment, my lord. There is a signature of my lord building. I am the, my lord.
We'll see that. What
assistant-
is your
yes,
role?
Yes, my lord.
The allegations are specific by name,
Yes,
maybe before the Director General of Police,
my lord.
but in the earlier on 31/7/2023,
Yes, my lord.
he might not get, he might be deprived of, he could not bribe you. That is a different issue.
Yes, my lord.
But allegations are specific.
Yes, my lord.
We'll look into that, whether that allegation is fortified in the case
Yes, ma'am.
diary. If you have a role and your custodial interrogation is required, we'll reject your bill. And if we think that, okay, your statement is required, no further custodial interrogation is required, we'll
Correct.
make the interim order absolute.
Yes, sir.
But so far relating to the other cases,
Yes, sir.
that was a case under 439.
No, my lord. One is 438, Pankaj Mohanian, my lord.
Yes, let us see.
Yes, sir. Pankaj Mohanian was released on bail. My
For
submission-
who was Pankaj Mohan?
Pankaj Mohanian is the person whose house has been, my lord, assessed. They have said wrongly, my lord. Actually,
What about the officers? Who assessed it?
that is document I have given, my lord.
Okay.
Yes. Assessment, abstract assessment. I want to show one thing, my lord. The signature, my lord. Assistant Executive Engineer Building. Assistant Junior Engineer Building. I am the, my lord, Executive Engineer now, my lord. Sorry, my lord. Earlier, my lord, I am the Assistant Executive Engineer, my lord. For the second case is concerned, my lord. Roads, my lord. And I am not working that, my lord.
Utpal Dole was the
ADC.
ADC revenue.
ADC revenue.
And what about the others?
Other assistant, my lord. He is the, my lord, at that time, Assistant Executive Engineer.
Gunaram Dole.
Jonaram Dole, my
Who
lord.
is he?
He is the Assistant Executive Engineer Roads, my lord, of the Themaji, my lord. On that block, my lord, the work, I think that work was not executed. He was called by the.
Now, who is Pradeep Deka?
I don't know, my lord.
It is not related to this case. Next
Deka,
case,
sir.
Mr. Huh?
No, no, my lord.
No, okay, that is so basically we are concerned with
Dole.
Utpal Dole and Junaram Dole, both
Yes.
Doles.
Yes, both Dole, my lord.
So your argument so far relating to Dole is that I am a ADC. I did not have, Utpal is an ADC.
Yes.
I did not have any role so far relating to the PWD assessment.
Yes.
Assessment is to be made by the PWD, and on the basis of that, the compensation is to be released.
Another thing is that, my lord.
Yes.
It was sanctioned on, my lord, 30, sorry, my lord, 1 minute, my lord.
What sanction?
The amount has been sanctioned, my lord. I am coming, my lord. Your lordship kindly come to that. That is important, my lord. I am retired from my service on 30/9/2022, my lord. Thereafter, my lord, your lordship will look.
Money was
sanction has been
sanctioned means money was sanctioned for payment.
That is my lord submission. And so far.
So your grounds are this.
Yes, my lord.
You did not have any role. Role in assessment.
In assessment of the my lord, house, my lord.
But there is not only the assessment of house, there are different assessments. Land assessments are also there, other
Yes, yes, sir.
compensations.
Yeah,
also.
I'm coming, my lord. The case is not that, my lord. There is a, my lord, in that, my lord, as per allegation him, my lord, that there are some house, my lord, and as per them, my lord, that house has been constructed, that house has been wrongly assessed. That is their case, my lord. So far, my second case is concerned, my lord. I am a PWD roads. I am working other division. The department called me. As per instruction of my client, my lord. Department called me and directed to assess the road as per their drawing, etc. When we made the assessment, not only me, I am only one of the members. There are other members also, deputy commissioner also, everyone is also
So
there.
therefore, they may require you all the interrogation together.
My humble submission, your lordship, is that, my lord.
Isn't it? Don't say that. Joint interrogation may be necessary.
But my lord, parity, my lord. All the person is released on bail. Pankaj
What do you
Mohan,
mean by parity?
Tarun Kumar, my lord.
What do you mean by parity?
Kamaljeet Singh, my lord. In respect of my lord, anticipated.
Parity means you are equally footed.
Yes,
Not equally footing is not the accused, that both are accused, therefore parity.
yes, sir.
Parity will be what is your role. If similar role, one is granted, okay, fine, we'll also give.
Pankaj Mohan has granted the bail, my lord. Your lordship. Only because his statement has been.
Sir Fukan, just pinpoint what according to you. First thing, do you require their custodial interrogation, number one. And number two is, what are the materials against these two persons?
Initially, what happened, my lord, in this case? Dhemaji-
Anything, Mr. So do you want to add something?
Yes,
Yes, just
my
take it.
lord. The Utpal Dole never made the assessment of the land, subject to my correction, my lord. Final report, not final, not submitted the final report, my lord. Utpal Dole. and he is the not authority also, my lord. And most important thing is that, my lord, Junaram Dole, my lord, he is the, I am stepping roads. A person is roads, my lord, call. And as per, my lord, what the World Bank drawing, my lord, the road has been assessed, my lord. And thereafter someone,
Is there any allegation regarding wrong assessment of the road also?
they never made, my lord.
There is no allegation affair. So therefore, to summarize your argument,
Yes, my lord.
your argument is that this Junaram Dole is an engineer of PWD roads.
And
They are-
the house has been as a PWD building.
And the house is assessed by PWD building. And therefore, even if there are some anomalies,
Yes.
I don't have any role. This is so far relating to
Yes, my lord. And it was done by Loboson one and others, my lord.
Junaram Dole.
Yes, my lord.
So far relating to Utpal Dole, you are a revenue ADC
Yes, my lord.
and buildings are assessed by the PWD department on the basis, because you are not expert,
Yes.
PWD department on the basis of that report,
Yes, my
you
lord.
sanction it. And so far relating to land and Jirat, it is on the
Yes.
basis of the report of the Mandal.
Yes, my lord.
This is your case.
Yes, my lord.
Yes.
And another thing is that, my lord,
Mm.
as per your lordship is more competent than section 9 and section 10, my lord. Notice was given, my lord. No objection has been given by the informant at that time. Subsequently, when he not got the, my lord, compensation, my lord, he filed the FIR one after
No.
another, my lord.
If he is not a party interested,
Yes, my lord.
in land acquisition, notice are given that will acquire this loan. Okay.
Yes, my lord.
Valuation is a later stage. Number one. Number two is an objection can be granted when it's a party interested.
Yes, my lord.
Party interested is
Section
defined in
9,
Land Acquisition Act itself, who is a
Yes,
party interested. So payment of excess money, if
Yes, sir.
somebody is aggrieved in a public interest or whatsoever, he cannot be said as a party interested in terms of the Land Acquisition Act. He may be a social conscious
Lordship is
person.
actually absolutely correct, but after section 4 notification, there's section 5. Why he is waiting for all these things, my lord? When his land was
Oh, suppose
not taken-
somebody
Yes,
learns
madam.
that there is a huge anomalies and excess payments are made. Is a
And-
citizen barred to
No,
come
no,
at
no,
a
no,
belated
no,
stage, or a court are barred
Yes,
not
yes,
to
madam.
look into?
Yes,
So
madam.
don't argue that point.
No, yes, ma'am. My saying that my parity is there, my lord. I have given also judgment, my lord. And when the Loboson was granted
Parity
bail,
with whom?
on the ground that he has given on
Parity with whom? Parity with?
Pankaj Mohan
Yen.
Yen, my lord. And Jonaram Dole was not working in that place. He was called.
So
Yes,
you are
sir.
seeking parity with this
Pankaj Mohan Yen.
Pankaj Mohanian.
Yes, my lord. And if your lordship go
Who
to the,
was he, Pankaj Mohanian?
he is the beneficiary, my lord. His house has been. my
Okay,
lord,
he's the
yes.
beneficiary.
Yes, he is the main beneficiary of that, my lord.
Okay.
And if your lordship go to the bail, my lord, the bail was granted like parity, my lord. If your lordship, Loboson was bail order. Third paragraph, my lord.
Sunil was arrested.
Yes, my lord.
Lobo was arrested.
After 5 days, he has released on bail.
Lobo was arrested. You are seeking parity with Pankaj Mohanian.
Loboson was, my lord, 5 days, one part, third part of the, my
You
lord.
want to be there
Order.
for 5 days? If
No,
you
no.
argue that we will providing,
no.
you will surrender for 5 days, take interrogation
No.
maximum
And
5
my lord,
periods.
so far, my lord, Pankaj Dole was, I was never called by the vigilance, my lord, CM vigilance. cell,
You
my
want to
lord.
go there?
No, my
Call
lord.
him.
That is my submission. my
What
lord.
happened, Lord?
And when I was in Dhemaji, my lord, Dhemaji police station, my statement was thorough. I was thoroughly interrogated, my lord, when I was in interim bail.
Okay.
So Donaram Dole concerned, my lord, I was appeared before the CM vigilance cell also. And my statement was recorded, my lord.
Okay.
In both
So
Dhemaji.
after interim, you have appeared.
Yeah, yes, ma'am. Before Dhemaji police station as well as.
You have cooperated.
CM vigilance.
You have cooperated and
Yeah,
you
I
will,
am
you are
cooperating, my
willing
lord.
to
That is my point.
you are willing to cooperate.
Yes, ma'am.
So
I'm ready to
you need
cooperate
not
with them.
take 15 custody.
Yes,
Yes,
ma'am.
Mr. Pukan.
Here, my lord, the initially case was registered, my lord, the Dhemaji PS. And all the order passed, my lord, at the time of when, my lord, the Dhemaji PS case was registered. Later on, my lord, when it was come to the knowledge, my lord, that it is above 6.33 crores, it is transferred to CM Vigilance matters. And now CM Vigilance has, my lord, investigate the matter. And it was transferred on, my lord, received on 19 March of 2024. And now, my lord, say huge, my lord, the amount, my lord, which was, my lord, involved in this case and economic offense, my lord, where, my lord, there is a modus operandi case and the
Mm.
parity ground which was taken by my lord.
What is the role of these two person?
My lord,
in-
the,
So far, your investigation.
my lord, the, now, my lord, I have received only, my lord, I have seen their statements.
Mm.
After, my lord, the interim, my lord, they have, my lord, the,
No, you do one thing.
Mm.
Since you are objecting the bail
Mm.
and they have recorded your statement,
my lord.
I would like to go through your objection on the pinpointed ground on the
Right.
materials on CD.
Right.
If you are not ready today, we can take it up on Monday.
My
They
lord,
are on
that's- my
interim.
lord, morning, only I have-
That's why. We'll look into on Monday. We'll take up.
Monday, yes, ma'am.
Okay. Mr. Fukan, learned public prosecutor, has submitted that he has received the case diary today morning only and would like to go through the same to assist this court so
Okay.
far relating to the materials implicating the present petitioners. Proceed. Accordingly, matter stands adjourned and be listed on 22nd. Interim order, pass earlier shall continue till then. You just go through it.
My lord, yes.
Specifically these
My
two
lord.
person.
Lord.
And two aspects. One is that they have cooperated, whether you need interrogation and what are the materials
It's true, my lord, they have cooperated, but the why their custodial detention is necessary, I go through them.
that you go through.
No, forget. Much obliged, my lord, thanks.
দুইটা কেস এটা
20th same, my lord.
Same, my lord.
same 28 same
Same.
Monday.
20. Why this matter is listed here?
In this case, the interim order was issued on 1st of March 24. CD we have received on 20 of March. But till 20 of March, not appeared. Subsequent is not up to date,
Yes.
I've appeared and I've voluntarily surrendered my.
Okay.
Till 20,
The learned additional public prosecutor submits that he may be granted some time to have the updated case diary.
Because some.
Updated case diary, it's in as much as the case diary is updated up to
28th of March.
28th of March 2024.
Four.
Prayer is allowed. List this matter.
Tinsukia, 2nd of May.
2nd of May 2024. Interim order, pass earlier shall continue till the next date.
Item number 31 and 30.
Yes.
Pursuant to this last order,
My lord,
this honorable court, my
I'm
lord,
appearing on behalf of our Mavinder for the department. Department seeking some more time to
To
comply,
do what?
uh,
Seeking time to do what?
to comply with the orders.
Huh? Comply with the order, contempt.
yes.
Kindly
What,
have a
where
look,
is the
my-
order?
My lord, order is that page 13, my lord. The relevant portion is at page 14, my lord, para 8.
Let us have some time. R. Muzumdar is here.
On legs in court
No,
one.
is in Guwahati,
Yes,
inside the court?
Yes.
Okay. Mr. R. Muzumdar, learned counsel for the department, submits that he has received a parawise comment and the department may be granted 4 weeks time, 4 weeks time to do the needful for compliance of the order in question. Prayer is allowed. Please this matter after 4 weeks. You do it on by the next date you update us. এখন দিদি
Possible, but any date.
Give a date. Give a date.
March of.
Give a date.
Operative part of the order is at page
Page
27, my lord.
27.
There is a fourth direction, my lord. In the middle portion, lordship will see Roman 1, 2, 3, and 4.
Yes, madam, are you appearing?
Your Lordship, Mr. H. Ali appears for this matter. He's not present today, Your Lordship. Personal
What is your
difficulty.
instruction?
As per last order, we were asked to file an affidavit. Affidavit has been filed, Your Lordship.
What is your stand in the affidavit?
Affidavit is not the address, my lord. The direction contained in the
What is the affidavit?
affidavit, lordship can have a look my copy, my lord. Which I have.
Who is your senior?
H. Ali, Your Lordship. Not available today. H. Ali.
H. Aliha.
Lordship, kindly have a look. The
No, understand, but it's a contempt. Suppose you hold that they have not filed. What to do?
I
She
received
can,
the copy, but does not indicate.
no,
my-
that is not an issue. We can have your copy. But yes.
But any day, madam, Monday, because since 2020, I'm not getting.
Subject that Mr. Saliha is having, Mr. Saliha, learned counsel representing the respondents, is having some personal difficulty today. Accordingly, a prayer for adjournment is made. Prayer is allowed. List this matter. Give a date next week. So, with effect from 4/4/2013, promotional and salary. Anyway, yes.
Can be taken after some time, Lordship. Arbor Puja is on legs, Lordship.
Okay, what is the issue here?
My lord, currently, see, lordship, order dated 18th, lordship, and 2nd of February, lordship.
Okay, okay.
After some time, Lordship.
35.
None appears for the petitioner on call. Though Mr. So learned counsel is present.
Your respondent has already retired, Your Lordship.
There are some implement also.
Yes,
But-
the newly implemented respondent number 5.
We also received it.
Only that's, I have a respondent number 5. Others notice. not
Just wait
disturbed.
for some time.
Yes, Your
Let us see. However, in the interest of justice, matters stands adjourned and be listed after 3 weeks.
Obliged.
Regular salary, we have paid, Lordship. GIS is under process. We have written to the different districts, Lordship.
A date may given after some days.
How much?
Lordship,
4
may I
weeks?
like to see my instructions.
4 weeks?
Yes,
6 weeks?
Lordship. 6 weeks will be. Okay.
MS Bora, learned counsel representing the respondent, submits that the arrears of salary has already been paid to the petitioner. And process for payment of
GIS.
GIS is going on. And it may require another 6 weeks time. Accordingly, 6 for an adjournment. Prayer is allowed. List this matter after 6 weeks.
Obliged.
Date.
Make a mention.
7.
But in 37 and connected item is also, my lord,
48.
48.
Mm.
So subsequently, we have filed the 37 after the filing of this item 48.
Mm.
We have filed one affidavit opposition annexing one circular, my lord. We have put to challenge in this case, my lord.
Now,
Now the case is otherwise ready for
Is a private
disposal.
respondent is there 37 item number.
Service
Whether
is
services,
complete as per law Ajama report is there.
what is lawyer?
service is not completed, I think. 6, 7, 8, 9.
Respondent number 6 to 9. Now what to do regarding the service? Tell us.
Service accepted, I think, my lord.
Where is that?
This is their note is
Huh?
office note and the law Ajama court order, I think they are.
Lodgemas order dated
Is on.
10/4.
Yes, yes.
Six, 7, 8, 9 ID card received with seal and signature.
But they are not appearing.
Okay, the notice has duly been served upon the respondent. Number 6, 7, 8, and 9. However, none appears for them. Be that as it may, list this matter in the admission column after 2 weeks.
Along with the.
Along with
Item number 48.
item number 48. What is that?
48 hearing.
Along with WPC
And double A 2022.
6, 9,
Double A 2022.
2022. Or 48 or likhi dibo. List this matter on the prayer of the learned counsel for the parties. List this matter after 2 weeks along with WPC 2589 of 2023. 48 or likhi.
No, 39.
My lord, the order has been complied with, my lord. A speaking order has been passed, my lord.
I received the copy, but the shortage of fund and medical authority has rejected the case of the petitioner on the ground of shortage of fund. They have not even paid the minimum wages.
Challenge it.
Yes, my lord.
Okay. Mr. Bora, learned counsel,
For respond number 1 and 2, my lord.
respondent number 1 and 3 submits that pursuant to this court's order, a direction passed in WPC 4773/2017. A speaking order has already been passed on 29/8/2023. Full stop. Same has been produced before this court. Mr. Purkasta, learned counsel for the petitioner, submits that in view of such speaking order, the contempt petition may be closed with a liberty to the petitioner to assail the order dated, speaking order dated 29/8/2023. Full stop. Prayer stands allowed. The contempt petition stands closed with the liberty as prayed for.
Obliged, my lord.
A copy of the order dated 29/8/2023 is kept on record.
Obliged, my lord.
Be kept on record. Yes, Mr. Bora.
It's a file and
Or
Actually, I was filed for extension of some time to lordship take necessary action.
take necessary action means what?
Cost was imposed lordship on us and it was directed to deposit it within 4 weeks lordship to the
Now,
legal-
what is your instruction?
and lordship as per my instruction affidavit, sorry lordship, appeal has been filed lordship, so this matter may be deferred for some time.
So you will dismiss it
Lordship.
because you say that you have preferred an appeal. And at the same time, you say we want to comply with this order. What is the meaning of that? Again, you are playing a fraud.
No, lordship, it is not.
Either way, you say that we are complying with, so therefore we need time.
Lordship,
We'll grant you time. You are saying we have preferred an appeal. So why should we give an extension?
lordship before-
Hard.
Yes.
MSR Devi, learned counsel for the petition. This court, under its judgment and order dated 12/2/2020, 12/2/2024, passed in WPC 7373/2022, while allowing the writ petition directed the respondents allowing the writ petition imposed a cost of rupees 50,000 upon the respondent with a further direction to deposit the same before the Guwahati High Court Legal Aid Committee within a period of four weeks from delivery of the judgment. Full stop. The present application is filed seeking extension of time with regard to payment of cost. Full stop. The learned counsel, however, submits that an appeal has already been preferred against the aforesaid judgment and order dated 12/2/2024. That being the position, this court is of the view that if such prayer can be made, such prayer for stay of such direction can be made before the appellate bench. Accordingly, this writ petition, this IA stands dismissed.
May it please your lordship.
Yes.
This contempt petition, the petitioner has expired and we have filed a substitution petition for substituting the legal heir of the petitioner.
What was the direction?
Lordship, earlier direction, to implement the new incumbent, your lordship.
No. There is a contempt petition. The petitioner died. So direction should be implementable relate to the, suppose there is a direction for promotion. The legal heirs will have no right to seek promotion.
No, this is
So what was the direction?
this was the
That is vital to allow this.
Yes, my lordship, this is the retirement benefit, gratuity and leave encashment.
Where is that order? That we must know.
Yes, my lordship.
Where is the main case? Read the main
This
case.
is a contempt petition. Order is at page 19 of the contempt petition. Your
Page
lordship.
19.
Yes, my lordship. Operative portion is at para 5.
The present application is filed for substitution of the deceased petitioner in connected contempt case C 153/2022 by the legal heirs. Full stop. The connected contempt petition was filed by the deceased petitioner alleging willful violation of an order dated 22/3/2021 passed by this court in
WPC 1930
WPC
1930
1930
2021.
2021. In this court, under its order dated 22/3/2021, directed the respondents to examine the deceased petitioner's claim for payment of retirement dues in terms of the representation filed. Full stop. That being the position, this court is of the view that since it is alleged that the aforesaid order has not been complied till date, the petitioner being the legal heir, the applicant being the legal heir, shall be substituted in place of the deceased contempt petitioner. Accordingly, present application stands allowed. Registry to correct the cost title accordingly.
Earlier blessed.
None appears for the petitioner on call. Applicant on call. List this matter after 3 weeks. Yes, like 43. But I have not taken, but this case. 43. Actually, what happened, my Honor? 40. Kuntu? But he has not taken my consent actually. My lord, in this case, my lord, I have filed a petition for vacating of the modification of the order. Entire DPC proceeding has been stalled. And that they have filed an objection. In which case? 43, my lord. No, not 43, it is 42. 42. This is 42, let's look at your list. 226 application. Brahmaputra crackers and polymers.
Yes, yes.
That is 42. We have already adjourned it.
Please, that's because actually my junior.
That is not our fault.
No, my lord, my lord. So in this case, my lord, I filed a petition for motivation. So.
Where is the writ petition? It is adjourned. Who is the product applicant?
43 plus 42.
Wait for some time, let us see. Huh? You have put a Brahmaputra polymer.
Yes, my lord. And it is very urgent, my lord.
No, we understand the urgency, but if the petitioner's counsel will not there, his name is shown.
Yes, name is shown. Yes, doctor.
We'll take up this matter. Wait for something.
Yes, ma'am. No.
Just let us record the dates. Ready?
Yes, but I also got a decision with
So just let us record the dates.
Lord.
Yes, Mr. Bhatt.
The petitioner was appointed as purely temporary contextual basis on 15/12/1978.
Temporary.
Yes. And the
There is
service of the
any appointment order?
no.
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 Okay.
Yes,
No formal order has been.
page 17,
No, 15/12/78, any order?
there is,
Page?
Maybe.
page 17.
Shiva Prasad.
Yes.
Yes, that is there, Mr. Bhatt.
Yes.
So that is just I want to note down so that later on we can look into it.
Then
Just to summarize the facts now. Yes.
Then
Next. Then
on 26/9/1983, the service of the petitioner was regularized. 26/9/1983.
regularized.
Regularized.
Hmm.
As per the order passed by the Honorable Supreme Court.
Page.
Page. Page 19, Annex 3.
Page 19.
Actually,
19 is not the regularization
Actually-
order, no? 19 is general order.
general order, on that basis, he was regularized.
This is an interim measure.
Well, that was, and after that.
Continue. Okay. And then thereafter?
That Annex 4, on 23/6/2017.
3.
23/6/2017. The respondent issued a notice order to submit the original age proof certificate.
Page.
Annex 4, page 22.
Yes. Then
Then
on 27 to 2017
You started getting regular salary from which date?
from date of regularization.
26/9. Okay.
And then Annexa 5.
Hmm.
27 2000
Annexa 5, page 22.
page 23.
What is Annexa 4 is page 22.
Yes.
And then what is the Annexa 5?
Page 23.
Date?
Date 27 20
27.
July 2017.
27/02.
No. 20
20
July
07
2017.
17. Hmm.
The regarding age proof certificate, original copy has already been submitted along with letter.
Then
Annex 6,
Hmm.
page 24.
this is page 23.
23.
Then
Page 24.
Hmm. tell me
Annex
the
6.
text first, then we'll go to the page.
Yes.
What happened?
Wherein this actually, if a person is retired from that department, prior 2 years, a list of employee declared. There you are going to retire on so
Okay,
and so
that's
date.
superannuation notice.
Superannuation
What was the
list.
superannuation? Okay.
This is the list of superannuation. But in this list, the name of the prisoner is not there.
Okay.
That
That
dated.
is not relevant for us.
Yes.
Okay, then tell us.
Then impugn order passed on Annex 7, page 25.
What happened here?
Dated 30/12/2020.
Hmm.
The respondent issued an impugn order that your service have completed and by tomorrow you will retire.
Okay. So they have counted your service from 15/12/1978.
Yes. As a pure temporary
Okay.
employee.
Now what is your case?
My case is that at the relevant point of time, I was a minor, about 12 years plus, as a canteen boy in Lansam, when my family background is very pathetic one. That's why the authority has on consideration appoint me.
What is your ground of challenge to this?
Down is challenge actually date of birth of the prisoner is not reckoned by the respondent authority, and that original death certificate, that means SSLC pass certificate, where my date of birth is containing, not challenged till today by the respondent.
Why should they challenge? This is your date of birth.
Yes, and moreover,
They have accepted it. Then
my pair is that as they have not challenged my date of birth, and my
as per your date of birth, as reflected in the matriculation certificate, you were minor on 15/12/78.
yes,
They have determined you to be minor only on your document.
Yes.
So they are happy with that document. They do not want to challenge it.
now my question is,
Yes.
the 15/12/1978, as I was a minor, but I have not getting the full benefit from the department.
So you argue that my services should be counted from 26/9/1983,
Yes.
on which date I was regularized for the purpose of my length in service, not the period from 15/12/78, because this was a temporary, casual, and a
Yes,
canteen boy.
this is my contention.
This is your contention.
Yes.
Okay. So therefore, they could not have calculated the 30 years from 15/12/1978,
Yes.
but they should count it from 26/9/1983. That
83.
should be my entry into the service.
Yes.
This is your case.
Yes.
Any judgments?
Yes. As per the Gopal Prasad judgment, first that Bihar.
Then if this is your argument, then 30 years is not even relevant for you.
No, 42 years.
From 83, what is your, what should be your, what was the Mrs. Rasudik, what is the 30 years or 62 or what? 30?
No, that is not, now it is 60 years, my lord. That 33 years of service is the earlier rule was there.
No,
It was an earlier rule. Now we
but
say,
here-
we have said,
Hmm.
since a person can be appointed only at the age of 18.
Hmm.
So his service, his date of on the date of appointment has to be treated as 18 years. And therefore, my lord, on,
no,
if.
are you saying that on 15/12/1978, for the any purpose, his date of appointment should be treated as 15/12/1978? If that be so,
No, no. my
that
lord.
will have a far
We said.
fetched
that-
ramification
that's-
upon you.
No, what we are saying,
Hmm.
that if a person is appointed at the age of 18
Uh,
and retires at the age of 60,
uh.
everybody will not 18 or above.
I understand.
Then,
That is, there is no quarrel on that. A person can serve a department either up to age of 60 years. Or
And-
if we take it to be the 18 years,
yes,
to 60 years,
42 years.
42 years.
No person
No person can.
walk,
But
and nobody in fact
We'll
is walk.
we'll go to that calculation later, a little bit later
That's
on.
right, that's right.
Now, admittedly, his entry on 15/12/1978 is as a canteen boy.
Canteen boy, yes, in the
Canteen-
FCA. No, right.
In FCI, canteen boy in FCI.
Where
Do
the-
you like to argue, and we'll record that the service for the purpose of service benefits should be counted from 15/12/1978?
Yes, because his,
Okay, yes.
because.
That may, just remind yourself that may have a far-reaching
No, he
ramification.
must have a qualifying service, my lord.
Huh?
That is qualifying service for the purpose of pension, that is a different matter altogether.
No, not different matter. Here issue is, which should be the rate, because a service will mean serving an institution. So the question would be, what should be the date of entry into the service?
18.
No, not age, forget about the age. Date of entry into the service, the original casual appointment or the regularization, date of regularization.
My lord, what is relevant for us,
Hmm.
what is his date of birth? What is his
No,
date of
birth
birth
or
is
relevance will-
relevant
Date of birth relevance will come
for the purpose of retiring.
retirement, for the
Retirement.
purpose of retirement.
retirement, right?
To determine that purpose of retirement, first we must ascertain what should be his entry into the service.
Yes, because,
No,
my lord,
what? According to it, 15/12/1978.
18, as 18 years.
Whatsoever is, forget about,
18 years,
forget
because,
about.
because he cannot, a minor cannot be appointed. And in the offer of appointment, we have said, produce your original, please produce
No,
your,
There is no quarrel on that.
and he did not, my lord.
He entered
Apparently-
into service on 15/12/1978.
Right, my lord.
Okay? 15/12/1978. Now, on that day, he was 12 years.
My lord, will kindly look, let one page, my lord.
Yes.
Lordship will kindly have come to this certificate. The date of birth certificate.
What was your age on 26/9/83?
29.
Certificate.
Alexa 1. My lord,
What
age
was your
16.
age on 26/9/1983?
12 plus.
No.
12 plus.
My lord,
83 not 12,
page
right?
16.
Huh?
Page 16 is his certificate. This was given.
There is no quarrel on the
No,
fact
I'm
that
not-
when he entered into service means whatsoever on 15/12/1978, he was a minor,
No,
12 years.
no,
Then,
because my lord will kindly come to page 16.
okay. Yes.
This certificate is issued on 26th of July 85. So this was not the basis,
No, this was not the basis.
not the basis.
Ah,
So we cannot say that this is the basis on which he was appointed. If this is the basis, then he is minor. This date is the basis because one has to have a date of birth, my lord.
so he is having a date of birth on
Date of birth on 85. Apparently, it is not in the 78.
In 78, what was given,
His date of birth is 1/3/1966.
as per this certificate given in 1985, when he
And you have
rendered,
acted on the basis of this certificate.
when he
only.
rendered almost 10, 15 years of service.
So therefore, first determination is, what do you mean by service?
Service means, my lord, therefore, my lord,
Service means a canteen boy service,
at the age of 18.
canteen boy service without regularization. As a service under FCI, we'll hold it, we'll record it to be your argument.
In fact, regularization is a different matter altogether. That is a different matter. What he said, my lord, in fact, throughout the country,
See, I'm telling you, entry into the service is having a very vital relevance according to this code. Suppose a person 2005 is a cut-off date for old pension, new pension. I'm giving a different example. So that depends upon entry into the service. Whether he will be entitled for pension in the earlier scheme or new defined contributory pension scheme. So what should be treated as a entry into the service?
initial appointment.
Initial appointment as casual. As anything,
If
a canteen boy.
No, my lord, if it is a regularization,
Hmm.
then that has to be initial appointment. If it is an appointment, subsequent appointment, then the
So
appointed
a person whose service is regularized at a X point of time,
regularization carries with the meaning.
X point of time, on which date the pension scheme applicable was new defined contributory pension, but he will be entitled for a pension taking note of his initial casual appointment.
That is under, if the scheme provides that, that is a different matter, my lord. If the scheme provides that, that is a different matter. I am not on that scheme, my lord. Scheme, that is a different matter altogether. But here, my lord, if it is, Lordship has rightly pointed out, if it is a question of regularization, regularization and
Where is the
requirement,
order of regularization?
it is not there. That is the problem, my lord. It's
Where is
not.
that?
No, it is not
You
there.
give us,
I am not very sure because I'll have to.
because there is no dispute that his service was regularized.
Then I'll check up, my lord. Then I'll,
On which date?
that because I am not sure, because it will have to be, because maybe from.
Where is your superannuation? Order of impugn order?
It's a 7. At page 25.
Yes?
Page 25. Annex 7.
And he has been given all the superannuation benefits in the meantime.
Where is your name?
Shiboprasad Best Google.
Serial number?
No, my lord, page 25 of the writ petition, it is a single name, single order.
Single order.
That is. Your lordship perhaps is looking into 24.
Okay, let him retire, pay him whole salary from 22/12/1978. All regular scale. Either way.
One retirement benefit. Retirement benefit, my lord, is.
No.
Let me tell you, Lord, what would be his retirement benefits. Pension, he's under, if a CPF contributory, it will be 10 months average, last 10 months average. In any case, even if it is counted from that date, the benefit will be this only. Nothing more than that. He will not get any.
Where is that regularization?
That I'll have to check up, my lord, whether it's there on record or not.
What
because
is your stand in the affidavit? See, as per his regulation.
we said pursuant to the order passed by the Supreme Court, the canteen boys, throughout the country were regularized.
I mentioned paragraph 5. But there is no special order of my decision.
My lord, can I make an endeavor, my lord, to
Yes, yes,
Get-
of course. See,
your lordship?
I'm open to ideas.
No.
But suppose he entered into as a canteen boy. And canteen Mazdoor Sabha went to Supreme Court. Supreme Court says, okay, why are you utilizing service like this? Give them the benefit, equal pay, something like that.
Well, there are two types of canteen boys. One was statutory canteen. Another is
These are not statutories.
These are not
statutory.
Yeah, because under the Factories Act.
That is the difference, because you must have a canteen in your. This is not the statutory.
That's not.
Because that were basically banks and all.
That's right. Your lordship
Isn't it?
Your lordship is aware of that.
So, he worked, admittedly, you have, as on 26/9, were granted the benefits of equal pay on 26/9/83.
83.
And the service
And
of
in
the,
fact, whether on that day even,
Yeah.
if we go by his certificate,
Ah.
he would be less than about 6 months.
okay, anyway, then what it say is that in view of the service of the petitioner was regular, effective from 26/9/1998 with due pay revision. That is your standard page 44.
Yes.
So if that be so, if we count his service to be under you on 26/9/1983, then when will be his 42 years or 60 years, whichever is earlier?
42 years.
42 years of service or 60 years of age, whichever is earlier, with effect from 26/9/19.
Yes, both will be same.
Huh?
42 years service
so-
or 60, both will be same. my lord.
No, him. He may be, his may be different. So if it is on 26/9/1983,
Then 28 to 2026, he will be retired.
Earlier, my lord has said earlier, 42. Whichever is earlier, then he'll go. my lord.
whichever is earlier,
Then he'll go.
from 26/9/1983, not from the 78. This is a view
No,
Just
that perhaps not.
subject to what you argue, because his entry was as a minor, as a casual.
No, that has to be established because
This is your stand.
we are not saying minor.
We are saying
We have never
the
said.
petitioner initially joined service as bearer in the Department of Staff Canteen of the district so-and-so at a lump sum rate of ₹70 per month by virtue of an offer of appointment issued to him by the.
We have never said minor.
No, you not said minor. Not said minor.
We said, my lord,
Suppose
that
his,
because
his,
we cannot
his,
also say.
his service prior to 26/9/1983 is wiped out. Question of minority will not even come.
Yes, that will not come.
That will not
Because
come. If that will not come, treat his appointment on
According to
83.
us, according
Ask
to
him to
us.
go on superannuation.
No, we have rightly done that. 42 years, we have rightly done that. Because
No, 42 years you have rightly done. But from which date?
from the date of his initial earn.
That is where this court is having a different view.
All right,
Can you count
I'll
that?
address your lordship on that because the Supreme Court has also,
Ah.
even if
Because if we hold that, in many cases so far relating to qualifying service, promotion, all these ad hoc appointments which is time and again it is well settled, that said that should not be counted.
no, if it is
That should not be counted except in master role workers where that qualifying service is lesser. Without giving any benefit, you can count that for the purpose
lord-
of,
my lord-
because always it's a beneficial.
there are number of persons like him because of canteen. All have been retired like this.
No, that is a
But-
different issue. They have not come before this court.
All have been retired.
We'll have to take a
All right,
decision.
my lord, I'll make an first, my lord, it's better, your lordship has rightly pointed out. I'll make an endeavor to get hold of that initial, the regularization order. That would be better, my lord, to
Because you
appreciate.
have taken a specific
No,
stand.
because that would be, my lord,
Heard Mr. Bora, learned counsel for the
my lord,
police.
the time because this is an old matter. I do not know where it was that.
The present writ petition is filed. This is an interesting thing.
Lordship, obviously, my lord.
See, we cannot rule out a situation when you have joined
Joined
78.
78.
15, 12,
78 in India, a minor boy working in a canteen.
He was apparently minor. Has to
Still-
be. Has to be.
Still, we are looking at, we'll experience everywhere.
Oh, that's right.
Isn't it?
That's
We cannot be oblivious of such a situation. First. Second is that in virtue of a Supreme Court judgment, their services were regularized. Now, for counting the service, maybe 42 years, maybe age of 60. Which should be the earlier?
It happened like that.
Suppose suppose if we, even if we take his service to be 1883.
83. Initially 1978.
83.
83
Then what will be his period of service and when will he retire in terms of his date of birth in the matriculation? 26. Okay. So. The petitioner is aggrieved by an order dated 30/12/2020,
Yes.
whereby the petitioner was asked to go on superannuation on
31/12.
completion of 42 years of service. Is that it?
Yes.
42 years of service. It is the case of the petitioner that though petitioner initially served the respondent with effect from 22/12/1978 as a casual canteen boy at the rate of rupees
As
75.
a office bearer. Well, I mean,
Canteen bearer,
Canteen.
not canteen boy, canteen bearer. At the rate of rupees 75 per month. However, in terms of a determination made by the Honorable Apex Court, the service of the petitioner with similarly situated persons were regularized with effect from 15/12/1978. No, that was the original.
He said 29,
83.
26/9.
26/9/1983.
That is according to him.
And therefore, his qualifying service, his period of service should be counted from 26/9/1983 and not from 15/7/1978. Per contra, the learned senior counsel representing Mr. Rashidri, learned senior counsel representing the Food Corporation of
PK
India, submits that when the petitioner entered into the service of the respondent on 15/12/1978, he was a minor.
No, this is not.
No. 19 should be counted from 15/12/1978, taking his age to be 18 years.
That's right.
And therefore, after completion of 42 years, he was asked to go on superannuation on 30/12/2020. Full stop. Therefore, the basic bone of contention is whether the period of 42 years / the service period of service rendered by the petitioner should be counted from 15/12/1978 or 15/12/1978, that is the initial appointment as canteen bearer, or with effect from 26/9/1983, that is 93, on which date the service of the petitioner was regularized. Services regulation. Full stop. At this stage, Mr. Rajthari submits that for
PK
proper.
Roy, my lord,
Sorry, PK Roy submits that submits that the effect of regulation dated 26/9/1983 shall be a relevant factor for determination of the dispute in question. However, such order of regulation has neither been annexed by the petitioner nor by the respondent in their affidavit. Accordingly, Mr. Roy submits that he may be granted 3 weeks time to obtain the instruction, obtain the specific instruction in this regard, and if possible, a copy of the order of regulation. First of all. this court is also of the view that the contents of such regulations, order of regulation dated 26/9/1983 shall be an important factor for determination of the present litigation. Accordingly, matter stands adjourned and be listed on after 3 weeks.
Lordship, I will give the date.
7th of May. Don't give 7th.
No. Seventh, well, it will be a holiday.
No, no.
I mean, because of the election.
7th May. Huh? It will not cross 4 weeks, no? 14th of May.
15.
As
It
per
will
heard.
be on 15 minutes.
Huh? 15th of May as part heard.
My lord, if your lordship permit the 43, 42.
Just a minute. Wait for some time. Wait for some time.
Taken at 2 o'clock because I have, if your lordship permit, can you be taken at 2 o'clock?
We cannot assure anything. Wait for some time. We are taking continuously. Yes, next case.
Lordship, an affidavit has been sent for vetting. Actually, our earlier affidavit got misplaced, Lordship, which is why we sought some time. Otherwise, Lordship, this matter can also be disposed of, asking the departmental authorities to consider their promotion. Because, Lordship, in the earlier round of litigation,
In this litigation, we don't have faith upon you. You have done many things. These pretext, that pretext. Maybe you are correct, so we will determine whether he is entitled or not. And if entitled, on from which date. Okay, because see, there are earlier litigations.
it was for grade 1, Lordship.
A grade 1.
Yes.
Once you said that this, once you said that he is not within so and so. Once you said that he has not passed.
Yes, that
Now he has passed the qualifying. So
What-
we want to have your affidavit.
Lord.
We do not want to relegate it to you. And again, force a citizen to come back to us. Okay? The learned standing counsel submits that he will be able to file the affidavit in a position within a period of 7 days from today. Accordingly, 6 for an adjournment. Prayer is allowed. List this matter on 2nd of May.
Can it be on in any other day, my lord?
Give a date.
Any other day, my lord, I don't have it.
8th of May.
Okay.
Yeah, the Gupta is in this matter. He is in
Okay,
another position.
It is submitted. Okay. It is submitted by Mr. K. Gogoi that Mr. H. Gupta, the arguing counsel, is having some difficulty today. Accordingly, a prayer for adjournment on his behalf is made. Prayer is allowed. Place this matter on
On 2nd of May, my lord.
2nd of May.
Deeply applied.
The password for the time being, let's make a this code number 26, but just coming.
What is this issue here? Accredited engineer,
Engineer.
equal pay. Yes, Mr. Nayak. Accredited engineer, PNRD.
Yes, Lordship, if he is ready, Lordship, we are ready.
Sometime. A long time she's sitting here.
Yes.
May I please your lordship, on last occasion, they said that they submitted that they have prepared their affidavit.
Yes, my lord, what happened, my lord, two paragraphs received one from SP and one from IGP, and not my selection board. Actually, affidavit is required to file by the state level police recruitment board. I will prepare, but I will file it. Because one of my colleague, he prepared a draft affidavit for the SP. SP cannot give all these things. He only
This
contacted
is
the
item number.
9, my lord. 2 weeks time may be given, my lord. I will file affidavit on behalf of the selection committee.
Anything survives? Tell
Lordship,
us first that.
let them file affidavit, Lordship.
What affidavit? Tell us. Will you be able to run, take a gun? Huh?
We try, Lordship.
Which is the selection year?
2014. It was,
2014. Your writ petition was withdrawn in 2019.
Yes, Lordship. I have stated.
Well, what action have you any complaint lodged against the lawyer? Why? Then why should we entertain this petition? It's easy to blame a lawyer.
Lordship, we are not blaming the.
You have blamed it. Blame a lawyer that without our consent, a lawyer has withdrawn their brief. We are not aware. We are sitting when 2019 that was withdrawn. Where is your complaint before the bar council?
That is not there. They
Then why should we entertain the second writ petition on the same facts?
Lordship, the fact, the actual fact.
We
was-
do nothing. We will appreciate
Lordship.
if you can, instead of blaming, along with blaming, you file a complaint against a lawyer who has withdrawn from the brief without a consent. Now, who will answer? Where is the chance for the lawyer to answer that he has withdrawn the brief?
They have not
Suppose
done.
a petition is filed
Lordship.
saying that you have withdrawn a brief without instruction,
Consent, right,
and you are not even aware.
Lordship. This is the
That,
fact,
alleg
Lordship.
that allegation, this other lawyer is not aware.
Lordship.
Is he a party here to respond that no, I have not, this is my instruction, this is my letter? Why should we believe it?
That petition was not decided by this honorable court, Lordship.
Forget about that. Your whole case is that our earlier lawyer withdrew the petition without informing us.
No. Whole case is not that, Lordship. That's primarily that the allegation is against the grievances against the.
That is
state.
fine. That was raised in the earlier writ petition.
Yes, it is there.
That
in this
earlier writ
petition,
petition was withdrawn.
Lordship, without our
Withdrawn
knowledge.
without your knowledge.
Lord.
This is your statement.
That
How
was-
do you know that lawyer that you might have written? So let us have an inquiry. Let us implicate the lawyer here a party. Is it fair to blame a person without making him a party? If somebody does it against you tomorrow,
But they have not made any complaint in the bar council.
no,
Lordship.
not
They were
made,
not.
but you have written in the writ petition.
Otherwise,
How,
I'm
who
not-
will respond to that?
Otherwise, at
This
this
is a petition to be dismissed with heavy cost. This is not the fair practice. You are blaming a person,
Lordship.
a lawyer. If he has actually done, we'll take action, even we'll refer it to the bar council, or we'll ask the petitioner to, if he has not done,
Very serious matter.
They have not made any complaint against that is.
then how can you write it in the writ petition?
Is as per-
Make him a party. Let him respond whether he is correct or not.
Lordship.
Why should we entertain a second writ petition? On the prayer of the learned counsel for the petitioner, leave
Lord,
this
will
matter
divide
after
into-
3 weeks.
Deep problem.
This is not for anybody. I'm not saying for any lawyer. It's a blame upon a lawyer.
Lordship.
Obvious, my lord.
Yes, next case.
For the appointment of arbitrator.
Yes,
Yes, my lord. We agreed for the appointment of arbitrator.
There's a letter from Web, my lord, this second, but they are not agreed, my lord.
now what is your stand? Tell us.
No, my
We agreed for the appointment of.
Yes, as per the panel of the High Court, lordship. Is there?
So we'll say agreed.
Yes.
My lord, this,
And why this petition?
this railway, my lord.
Now who will pay? Suppose there is an award. Who will pay the interest for this period that this is pending here?
Actually, we are agreed to pay madam, the amount, my lord. It is reflected in our
That is
affidavit.
not
my lord.
our due. You want to pay them.
Only on, yes, my lord, but the interest part is
Hard.
there.
Mr. Ahmed, A.A. Ahmed, learned counsel for the petitioner, also had Mr. S.K. Mehdi, learned CGC. The present application is filed under Section 11 of the Arbitration and Conciliation Act 1996 for appointment of arbitrator in terms of contract agreement number, page 2. Okay.
In paragraph 21, we agreed to pay the amount, my lord. The interest part is there, my lord.
We are not saying anything
Yes,
on merit.
yes,
Anything we
yes,
comment that will
Yes,
be.
yes, please.
Mr. S.K. Mehdi, Learned Counsel for the respondent railways, submits that on instruction submits that the railways shall have no objection if an arbitrator in terms of arbitration arbitrator from the panel of arbitration in terms of notification number 1999 issued by the registry of this court. Full stop. Shall not have any objections. Yes, give a name from either.
Agreed, my lord. Once some Sairani, the customary district judge, my lord.
Okay.
We agreed.
Okay.
Nearest, my lord.
The parties has also agreed to the name of Srimati Sayarani Goswami, retired district and session judge of Assam, for as the arbitrator. Full stop. In view of the aforesaid consensus, and in view of the consensus, the present application stands allowed by appointing so and so. Registry will forward a copy of this order to Ms. Sayarani Goswami, and parties shall appear before the arbitrator
After 2 weeks.
Yeah, my lord, arbitrator will issue notice, my lord.
Okay, we'll stand here.
Yes, my lord.
Dispose of. What? You'll give the address of Sayarani, we'll get it from the registry.
Probably there is a copy, my lord.
Huh?
In record, maybe there is copy, my lord.
No, you want a copy? We are having it.
Yes, yes, yes.
Huh? Keda hai
What is that being passed over? Other side was. also
We'll
here.
come back, let us go, because if we, are you going for disposal?
Yeah,
If you will go.
maybe
for,
if
it will,
possible,
Ah.
that should be taken up for disposal.
it will take some time, so we'll continue. Let us see the short matters, let us finish the.
Or otherwise, my lordship may fix it in the next week
Okay.
on a hearing day.
As the
On a
agreed
hearing
with the
day.
learned counsel for the parties, list this matter on give a hearing date.
Tuesday, Thursday,
Thursday, next Thursday. 2nd of May,
2nd of May.
25th of April,
25th. Yes,
25th.
obliged.
Yes. Date of birth.
There is a
None
some,
appears for the petitioner on call. This petitions and dismissed for non-prosecution. There is a history of this case. Brief has been withdrawn. Nobody is appearing. No.
lordship.
Let us see if somebody
Even
comes.
lordship, they have approached the Honorable Delhi High Court also. That was also lordship. Obliged, lordship.
Dismissed for non-prosecution. Though
Obliged.
Mr. K. Gogoi, learned counsel representing the Union of India. is present.
I am appearing for respondent number 9 and 10.
You are Mr.
DK.
D.K. Roy and Mr. D.K. Roy for respondent number 9 and 10.
Obliged, lordship.
Yes,
My lord, here finance is required to file an affidavit.
respondent number 4.
For my lord, I am praying for some accommodation. We are awaiting the instruction. Matter is pertaining to regularization.
Mr. Porpuzari, learned counsel for the finance department. Pressed for and is granted 3 weeks time to complete his instruction and file affidavit. List accordingly.
I am so obliged, my lord.
May it please, Lordship.
May it please your lordship.
Yes.
Lordship, I am for the respondent number 7 in this matter. As per the last order, lordship 16/02/2024, this honorable court has directed to file the affidavit for the respondent number, or on side of the respondent number 2, which the reply has been filed, your lordship, by the petitioner and by the respondent number 2, that is
We
the
have
education.
filed our affidavit, your lordship.
Yes, lordship.
I have also filed
Number
reply,
two.
lordship.
Since we are the newly engaged counsel in this matter, your lordship, we have not
You are
received
representing whom?
respondent number 7, your lordship.
That who has been selected
Yes, your
without
lordship.
recommendation of name.
Yes.
Yes, lordship. There is a notification, your lordship.
Have you filed affidavit?
Not yet, your lordship.
Yes,
Since
file,
we have,
lordship, file, file.
Huh?
since we have not
Earlier counsel
received,
file, lordship.
we have not received any copy of the reply, your lordship.
Who will give you copy?
Lordship, respondent number 2 and the petitioner.
Have,
Uh,
have you?
Yes, sir. Earlier counsel is there, lordship. He got
So
the.
that cannot be a ground. If earlier counsel is given, that is given. Rest is up to you. Yes, what to be done today?
Then lordship, grant us some time to seek instructions, your lordship.
You are
Uh,
MS
M. Zomanpui, I'll write it down.
M
M. Zomanpui.
M Chuang P. Legislature Learned Counsel submits that she has been recently engaged in this matter and therefore requires some time to go through the pleadings of the parties. Accordingly, seeks for an adjournment. Prayer is allowed. List this matter. That affidavit is filed
Your lordship, our
in terms of this
affidavit-
court's order dated 6/3.
our affidavit filed on dated 12/3/2024.
does, no?
Yes, your lordship,
In
on
terms
behalf
of
of
16, that
respondent
has been
2.
respondent number 7.
Two. Secondary, Director of Secondary Education.
Okay, Director of Secondary Education. That has been filed.
Yes,
Yes,
sir.
yes, also file. I have
Okay. Accordingly, list this matter. When?
Lordship, any date after 3 weeks.
Why 3 weeks? You are enjoying
2 weeks, your
without
lordship.
any recommendation. Now these precedents are also selected.
Yes, your lordship, because there is a one, we have stated in our,
Okay. We'll
we have
not-
stated
since
in our
it is
affidavit,
adjourned,
your
we are
lordship.
not,
Okay,
wasting.
it's clearly
DC
covered by
has-
judgment, lordship.
DC has
Judgment,
power,
they
your
have
lordship.
clearly
Yes,
explained.
As per the order dated, your lordship, new notification.
List this matter. Give a date.
On date may be given.
Give a date. 7th of May.
Maybe election in.
Election, that will just mark it. 9th of May, 9th of.
Deeply august. 17.
No affidavit.
I'm seeking some accommodation for the time being, my lord.
Secondary education. Why secondary education here? Is it education matter? Huh?
I think number
17 is, my lord, pertaining to industrial tribunal.
What is this then?
Muhammad Ali, Muhammad Ali. The appointment, having a regularization.
Here also. my
Yes,
lord,
Mr. Das, have you filed affidavit?
My lord, I need some time. One instruction I have got that.
Are you having any role?
Limited role, because so far as Farah's post is concerned, we have already written to the judicial department for creation of the post
Huh.
and if to regularize his service, but there is no response from judicial department as of
Now,
now.
who is representing judicial department?
Judicial department will be government, my lord.
Government.
Yes, Mr. Sutia. Judicial department. Affidavit is required.
Judicial department is the administrative department out here, my lord.
Basically, judicial. Mr. Sutia, learned counsel representing respondent number 3, comma, Mr. Borpujari and Mr. Borpujari representing respondent number 2. Praise for and are granted 2 weeks time. 2 weeks or 3 weeks? 3 weeks time to file affidavit in opposition.
I am for 5 and 6.
In the meantime, Mr. Das, HK Das, Learned Standing Council, Guwahati High Court may also file affidavit if so advised.
Petitioner provide me a copy of it.
Yes, madam, give it. Will not pass any order. This is
I'm
in
okay.
your interest. Yes, affidavit.
This. আপনি file করবো last time this was deferred because another expedition was filed and
That is 4963.
my friend is there.
4963.
Whether he wants to file or not, I don't know. But this matter is to be heard, Millard, finally.
What is 4255?
4255, I am appealing.
Have you received the copy of the affidavit? Do you want to respond? No.
They are replying.
Now, what to be done today?
It was fixed for to final disposal of WPC number 4255, my lord.
Then, are you going for final disposal?
Millard, if my friend is ready, Millard, then I can start the proceedings, Millard.
Yes, my lord, my senior Mr. Kane Chaudhary will appear, my lord, if he can start.
No,
collecting
not peaceful. If you both are there, I will do.
We do one thing, my lord. Today is the motion day. Let there be a hearing day. Lordship will fix and Lordship will
This
take up.
matter is ready as regards pleadings accordingly. The learned counsel for the parties submits that this matter these matters can be taken up for final disposal at the admission stage. That is allowed. List this matter on.
Short date, my lord, short date.
Give a date.
Next week, if possible, my lord. There is some urgent. I'm not insisting, my lord. I know my lordship's calendar, but even then I am praying. My lord,
First week of May.
Who knows whose calendar?
my lord, it goes when we spend time inside the courtroom, my lord, we do get some idea, my lord. 19th.
Can it be on 7th of May, my lord? It's Tuesday, my lord.
He's saying urgency.
Oh, election.
30th April.
30th April, possible? 30th of April.
30th. Obligation.
My lord, interim order make.
Interim order pass earlier shall continue till the next date of listing.
My lord, highly obliged.
Lordship, 2 weeks time will be granted Lordship to file affidavit.
Ms. R. Devi, learned CGSC,
Please.
appearing for the respondents. Earlier also you granted them respondents. Praise for and is granted
2 weeks time, Lordship.
2 weeks time to file affidavit in opposition.
Obliged.
Any interim order? No.
No, Lordship.
24.
Please, the Lordship. Lordship, in the last instance, we were supposed to file an affidavit in reply, but we have filed it today, Lordship, and we have served the copy to the.
Today I have received.
Okay, it is submitted that a reply affidavit has been filed today itself. Same is not on record. Registry to verify and take. List it on after 2 weeks.
Lordship, in the meantime, interim may be continued, Lordship.
Interim order pass earlier shall continue till the next date of listing. Give a date. 10th of May. Yes, Gogoi, no affidavit. He says that AIMS Delhi has cleared him and Guwahati is not accepting him. Is it correct?
He is not qualified, Lordship. I'll place it by way of
Okay.
affidavit, Lordship.
Mr. Gogoi, learned the CGSC, appearing on behalf of the respondents,
Lordship.
prays for and is granted
3
3 weeks time to file affidavit in opposition. Affidavit in opposition. List accordingly. Interim order pass earlier shall
Lordship.
continue till the next date of. Yes.
Look, can I take little liberty? The earlier matter,
30th of April.
30,
30.
today.
We have no problem, but no problem. Which even is started, but everybody said on some hearing date. Okay, hearing date. He's Friday.
He's enjoying a stay order, so
No, no, I prayed for hearing day because my senior was not there. If he wants, my lord, I can proceed, my lord. Now also I can start. There is no problem, my lord.
Next week. If you say next week, we can fix it next week.
My lord, urgency is
Mr.
my part also.
Keep a date. We have other
Yes.
restriction 38.
30.
30.
Yes. Oh, it's okay. It's a hearing day, my lord.
It's a hearing.
Hearing day, that's why. Hearing no longer. 44. What is part heard? This part heard? I forgot.
That matter, where
That
13 years.
juvenile justice.
My lord.
Where Mr. Goswami was there.
I can, my lord, after some time, my lord, I can contact him, my lord. Or some other day as your lordship.
Some other day.
As your lordship.
Next week we'll take it up.
Any date, my lord.
Okay. Mr. Goswami was supposed to
He
address.
was entrusted with the brief.
It is submitted that Mr. P.N. Goswami, Learned Additional Advocate General, is having some personal difficulty today. Accordingly, an adjournment is sought for. Prayer is allowed. List this matter.
25th, my lord.
25th.
Obliged, deeply obliged.
That matter, I have not gone through. Then I think, what is this part?
I'll inform Mr. Goswami.
Yes, yes. Just tell him.
I'll
And if any difficulty on that day, just tell us, we'll change that date. And we'll finish it up on next day. This is because this
My
is
lord.
a matter of 2014.
14. I'll call him right now.
Yes. What is this, Mr.
My lord, actually what happened is his name is Himanjal Kolita. He claiming that he is OBC. But at the time of application, he did not furnish any caste certificate.
What is
or
the selection?
Selection for the post of my lord, CDB under Social Welfare Department. Selection was for the post of Child Protection Society. No.
No. The protection officer for non-institutional care for district child protection unit.
So he has no case, my lord. He has received the
I
record
have
also.
received the records also. My learned senior is appearing for private respondent.
I am a private respondent 3, 4, 5, 6, and 8.
I have received the records. On last occasion, I have been we were directed to produce the application form of the petitioner along with the other selected candidates.
Who is the counsel for the petitioner?
So, M. Hello.
He will not come. Apparently, my lord, Kolita title is in Assamese, he is general caste. He cannot claim his OBC.
And what is that application says of the selected OBC candidate?
They have the selected candidates, they have mentioned as OBC.
OBC.
Let us see.
Two of the selected candidates at page number 9 of our affidavit. And this is the application of the petition.
This is a selection of which year?
The selection
2016.
2016.
16.
2016 basically advertisement was published in the year 2015. Appointments were actually made in the year 2016, January 2016.
What is the advertisement?
The affidavit at page number.
Forget about that. We'll dismiss it for default. Let us see. In absence, we will not like to dictate a judgment on merit.
Yes, yes.
Is not it?
Yes, yes, my lord.
Advertisement any specific that OBC reserve any category,
Yes,
anything
provision is there.
in the advertisement?
Yes.
In the advertisement, your lordship,
Where is the advertisement?
reservation for SC, ST, OBC shall be as per existing rule prescribed by government of Assam.
Okay, none appears for the petitioner uncalled. This matter pertains to a selection process for the appointment of
For the appointment of protection officers for
protection officer, child protection officer.
Child protection.
Child protection Assam. Protection officer
for
non-institutional care for district child protection unit. Unit. Yes.
I was in court number 20.
Yes. Ready?
Can it be taken at 2 p.m. Lordship?
Our list is over.
This is over.
See, go through this. Everybody has declared it. Everybody has declared except you.
Lordship,
Hey,
the only question this Honorable Court has to decide is that whether I have applied as a OBC candidate or
No.
not.
You have not applied as OBC candidate, others has applied as OBC candidate.
Because in the form, Lordship, there is no.
No option, but advertisement says there is a reservation as per, and everybody has declared that though there is no form, everybody has said OBC.
OBC, SC like that.
OBC were in the form itself.
No, not in the form, but everybody declared.
In the form, in the application.
We have supplied the certificate in the form. We have attached the OBC certificate along with the form.
It's not there.
Otherwise, Polita cannot belongs to OBC candidate. Who issued this certificate?
Certification nahi रहता है.
Otherwise. नहीं क्या मतलब
No,
Not there. Not there.
this is the original.
But as per the petitioner, Lordship.
But that is not, they go through it. That's why I'm saying, see, you have that permanent resident certificate, then high school living, board of secondary, Nagaon College provisional certificate, Nagaon College certificate, mark sheet, diploma, performance appraisal, then certificate by principal magistrate juvenile justice, probation officers. So what to do? Close it. Huh?
Because the statement of the petition is that, Lordship, yes.
But this is the original
Records reveal something different.
This is, you can go through it. And I do not think these are serial numbers are there. All pages are having serial numbers. Hard. Mr. Chancellor Learned Counsel for the, this is item number?
45 and
M.
40.
Halloi Learned Counsel for the petitioner. Also heard Mr. Sutia.
I am for 3, 4, 5, 6, and 8.
Respondent number 3, 4, 6, and 8.
3, 4, 5, 6, and 8.
8. And Mr. Bora?
1 and 2.
1 and 2. And M. Boro. Your name, please? Huh? P. Thakuria for? Respondent number 7. The present writ petition is filed just help me in the advertisement and all, okay?
Advertisement. Lordship,
Just a minute, while assailing a select list dated 6/12/2015 published by the member secretary, State Child Protection Society, Assam, for the post of protection officer within bracket non-institutional care bracket close, with a further prayer to appoint the petitioner as protection officer for within bracket non-institutional care, considering his merit position and work experience in the said office. It is the case of the petitioner that petitioner that though the petitioner belongs to OBC, an advertisement was issued by the member secretary, State Child Protection Society, Assam, for filling up of certain posts of protection officer for non-institutional care for 27 numbers of this for district child protection unit, totaling 27 in numbers. Such advertisement dated 2/12/2013.
Yes.
Full stop. The petitioner participated in the said selection process. It is the grievance of the petitioner that though the petitioner belongs to OBC category and certain posts are reserved / earmarked for the candidates belonging to the other backward OBC category. However, ignoring the merit of the petitioner, the respondent numbers
3, 4, 5, 6,
3 to 9.
7, 8.
3 to 9.
3 to 9 were appointed. 3 to 9 were appointed. It is the further case of the petitioner that in the standard form of application, there is no provision to disclose the category of an OBC candidate, though there is provision for disclosure of SC and ST candidates. And accordingly, the petitioner could not disclose his status as OBC candidate in the form, and in the form, though he has annexed his OBC certificate along with the application form, and therefore the respondent could not have ignored his candidature and better merit position and better merit position. Full stop. This court, under its order dated
15/12/22.
under its order dated 20/09/2023, after perusal of the application form, found that there is no provision for furnishing as to whether the petitioner belongs to OBC category or not, whether a candidate belongs to OBC, not petitioner, belongs to a candidate, belongs to a OBC category or not. Accordingly, this court directed to produce the record of the selection process, including the applications filed by the petitioner and other respondents. Full stop. The aforesaid record has been produced before this court. The application form filed by the petitioner in original is also produced. Same discloses that there is a provision for disclosure of status of candidature so far it relates to scheduled caste, schedule and scheduled tribe, and there is no provision for disclosure of status of OBC candidate. Full stop. However, at the same time, it is seen from the application of the petitioner that he has not annexed any copy of the OBC certificate issued in his favor. This court has also perused the applications filed by the other applicants, which discloses that the other candidates have not only disclosed their status, OBC status, but also annexed the OBC certificates along with their applications. The advertisement itself declares that certain posts are earmarked for OBC category candidates. Full stop. It is true that there is no provision for disclosure of there is no provision for disclosure of OBC status in the standard application form as published in Assam Gazette Part 9. However, the advertisement specifically declares that there shall be reservation for SC, ST and OBC. And there is also provision of annexing the required certificate. However, the petitioner has not annexed such certificate. In the aforesaid backdrop, this court cannot find fault with the respondent authority in not treating the petitioner as OBC candidate, inasmuch as the petitioner has failed to annex his OBC certificate. Had it been a case that in spite of annexing OBC certificate, the petitioner's candidates is rejected, the entire case would have been in a different standing, and this court could have interfered on the ground of non-disclosure of the non-consideration of the candidature of the petitioner. Accordingly, in the given facts of the present case, this court finds no merit in.
In future, if any vacancy arises, case may be considered.
Which vacancy?
Any vacancy.
No, that cannot be. You apply, then come that.
Okay. Fresh cause of action.
Fresh
We are saying that he's not belong to OBC category.
Full stop. What is your stand? Okay, that being the position, this court finds that the action of the action, therefore, the action of the respondent cannot be treated as an arbitrary action resulting in violation of the right of the petitioner under Article 14 or 16 of the Constitution of India. That being the position, this writ petition stands dismissed.
That
Cannot be. It's absolutely new thing.
There's an interim order
There is
that may
an
be
interim
vacated.
order, one post was kept vacant.
In interim order passed earlier stands vacated.
1/2/2016.
Huh?
1/2/2016. One post was kept vacant.
We'll say interim order passed earlier
One post is lying vacant, Lordship. That is why, Lordship.
stands vacated.
Without selection, how he can be
Let him participate, Lordship.
No.
Election, Lordship.
You participate.
Lordship, that is why I'm.
See, law is settled. Until and unless you apply for any that S bar, anything, we cannot pass a blanket order. That is well settled. There may be some other candidates. The original records are returned back. Just can we give it on Monday?
Yes, Your Lordship, then the whole file can be.
Keep in the file. Because may not be possible. In view of the order passed, so contempt petition stands closed. Yes. Next.
I think 47.
Lordship, here in this matter, Lordship, a specific instruction was sought for that whether the ACR, whereby his remark was not satisfactory, was communicated in writing to the petitioner. Lordship, I have received the instruction, but it is not very clear, Lordship, whether it has been communicated.
So what to do today?
Lordship, may I pray for 2 weeks further time to get that specific
Instruction in terms of?
In terms of whether the ACR of
Which order?
Lordship, there was an order of the court dated 14/3/2024, Lordship.
Okay. Mr. Upamanyu.
Yes.
Learned counsel submits that though he has received instruction in terms of discourse order dated 14/3/2024, however, same is not complete and clear. Accordingly, he prays for 2 weeks further time to obtain the exact instruction in terms of discourse order dated 14/3/2024. Prayer is allowed. List this matter after 2 weeks.
And your date may be fixed.
Give a date. List this matter on give a date.
Highly obliged, Lordship. Your Lordship, I am for respondent 3.
As doctor for respondent.
Timing, I think 26.
48 years. What's no? Where is PP?
Was there, man. My lord, in fact, in this case, my lord,
That's why.
My lord,
Yes, Kal. Yes, what you say, Mr. Vishwas?
my lord, page 48.
Page 48.
Absolutely carbon copy case, not even an inch more or an inch less.
Yes, Kal, what you say?
My false submission, clarity cannot be a ground for seeking bail. In this case, Lordship, I want to rely on Tarun Kumar's case.
Now let us understand the facts.
No.
My lord,
Same case.
same case, same facts.
Now who are you?
I am Charles Date Burma. My lord will kindly read page 48 order for the facts, and then I'll indicate from the record that I am situated.
Page 48.
Page 48 for the facts, your lordship will read this order, and then I will indicate from the record that on the same date, same vehicle, these 3 persons were arrested.
48 it starts. Where is the facts?
Facts. My lord, will kindly come to page number
51.
51.
So you want to say this registration number HR Swenchu was checked that Amingao contraband suspect to be herein 500 kg were recovered from the aforesaid vehicle. Concealed in the cabin of the vehicle driven by one Muzammil Hussain.
Absolutely.
Okay. The said Muzammil Hussain confessed his involvement in illicit trafficking of the said contraband for monetary benefit and he was accordingly arrested. Is in statement recorded and revealed that Vishal Dev Burma.
That is the present petitioner.
Okay. Bayar Dev Burma.
Who is on bail.
Is on bail.
Is on bail by this order.
Okay. And
Saison Dev Burman.
Bikram Dev, what about Bikram Dev Burma?
Bikram Dev Burman, I am not holding the brief for Bikram.
You are for Vishal.
I am for Vishal. I was for Bayar. I was for Sahisan.
Sahisan Dev Burma.
Sahisan Dev
Were
Burma.
as associate suppliers of the Sej Ganja.
Now my custody is more.
How many witnesses examined thereafter?
Thereafter, man, 2 witnesses, 2 more witnesses.
Okay. What is the next date fixed?
Next date, my lord. Next date, next date it will be probably there in the record. I can, in the meantime, my lord, my junior will.
Okay.
Record to the
Yes, Mr. Kal.
Lordship, regarding parity.
What about no, not parity? It's not a case of parity. It's a case of facts.
Lordship, I further want to submit that.
Because these facts we have granted on the basis of certain facts. That facts are still available.
Lordship, in the meantime, the co-accused approached the Honorable Court by bail application 4633. And this is the order whereby his bail application is rejected by this Honorable Court.
Who is that co-accused?
Lordship Bikram Dev Burma. In that case, Lordship, Tarun Kumar's case also.
No, no, wait. Before.
Yes, what you say about this?
My lord, this was just now handed over to me. I'll just, my lord, I just want to know the date of that order. That is important, my lord.
22/2024.
22/2024. Now, my lord.
Subsequent to this order. This order was also shown, I think.
Yes. So probably, my lord, this order which the NCB is relying, and the parties did not bring to the notice of the court that, my lord, there is a judgment of the
No,
Supreme Court.
here it is dealt with.
It was a
Parity.
It was pointed out by me, Lordship, before the lower court.
My lord, will just bear with me for
Just a minute.
yes,
Just a
yes,
minute.
yes, sir. A copy of it. Vikram Dev Burman naam.
That was the ground that others were granted bail. So court says that parity is not applicable.
Now, my lord,
This is the latest judgment of Honorable Supreme Court. Here, Lordship, paragraph 8 may kindly be 8th of appeal. Paragraph 8.
This will be applicable so far it relates to Muzammil.
No, Lordship, here, Lordship may come to page 30. Page 30.
Page 30
Yes, sir.
of this petition.
Bail application.
Bail application. Page 30.
What the authority investigation is collected.
Have you filed any objection here?
Lordship, one objection was filed. Lordship. The copy was also sub in my learned friend.
Okay, page 30.
Page 30.
Excellent.
What is the name of this petitioner?
Vishal De Burma and Sasyan De Burma. Taishon De Burma.
Here two petitioners.
Two petitioners. No. The two petitioners in page 48.
Here only one, Lord.
Here only one.
Yes, here would see only one.
You are Vishal in this case.
I am Vishal. Now, my lord, I'd like to.
Just a minute.
Absolutely. Don't want a judgment to this. It wasn't Torun Kumar.
Who has been examined till date?
Till date, my lord, 3 witnesses has been examined.
Who are they?
The FSL.
Chair is there. You go through it.
Yes, sir. My lord, in the meantime, my lord, may I just two, three things. My lord, this judgment of Vikram Dev Burma, if I may say, my lord, this is a judgment passed par incuriam. Now, for two reasons I am saying this. Because this judgment is subsequent to the judgment of Vikram Dev Burma. Now, it was incumbent on the, my lord, on the parties appearing on that day to apprise the court that when the bail application with regard to a particular FIR is entertained by a particular single bench, then subsequent bail application should go to the same bench. That fact was not apprised to the court. Further, my lord, I do not see anything in this judgment which at all discusses the order dated 1/12/2023, passed in BA number 3548/2023. No discussion. One liner I found, my lord, where it says co-accused have been granted bail, but there is no discussion, my lord. And my lord, the parties who appeared on that day, they did not inform the court that this matter should go to the same bench. My lord, why this same bench matter came up, my lord? It came up because of two judgments of the Supreme Court, my lord. One judgment, there was a tendency was, my lord,
That's
sorry.
why this matter is before this bench.
Yes.
I'm taking bench
Yes.
three, these are bails are
Yes.
coming.
Now, my lord, why I am saying, because this was the precise reason. Because in Allahabad, what happened, my lord, in same set of facts, my lord, there were difference of opinion. Then the Supreme Court says it. Then in another judgment of the Supreme Court, the Allahabad bench instance was made applicable to the entire country. Now, my lord, this judgment, when it was passed, one thing was Tarun Kumar was cited. Therefore, my lord, I was apprehending that Tarun Kumar will be cited before this court also. My lord, with utmost respect, my lord, Tarun Kumar, my lord, will just read two paragraphs of Tarun Kumar. Tarun Kumar has been wrongly quoted by the NCP department in every case. My lord, kindly come to Tarun Kumar, my lord. I have given a copy of Tarun Kumar from SCP online. Para 18 and para 19. Now, my lord, I do not know why Tarun Kumar, this para 18 and 19, why these are not relied on. My lord, para 18, fourth line. The submission of learned counsel, Mr. Luthra, to grant bail to the appellant on the ground that the other co-accused who were similarly situated as the appellant have been granted bail also cannot be accepted. Now, my lord, the next line is important. Now, my lord, the next line, my lord, will see. It may be noted, this is the observation of the court, my lord. It may be noted that parity is not the law. While applying the principle of parity, the court is required to focus upon the role attracted to the accused whose application is under consideration. If the role are identical, then parity will come. If the role is not identical, role attributed, while applying the principle of parity, the court is required to focus upon the role attracted to the accused whose application is under consideration. It is not in dispute. My lord, these are on the facts. I'll skip the facts. My lord, will come on the law at para 19. It is, my lord, before I go to para 19, my lord will kindly give, my lord, I'll just take, my lord, bear with me for few seconds, my lord. Here in Tarun Kumar, the Supreme Court was of the opinion, Tarun Kumar is when a wrong law is laid down by an inferior court. And when it is challenged in a superior court, then the superior court will not be bound by the illegal order of an inferior court. Because, my lord, Article 14 is positive concept. This is precisely, it is axiomatic that the principle of parity is based on the guarantee of positive equality before law enshrined in Article 14 of the Constitution. However, if any illegality or irregularity has been committed in favor of any individual or a group of individuals, or a wrong order has been passed by a judicial forum, others cannot invoke the jurisdiction of the higher or superior court for repeating or multiplying the same irregularity or illegality or for passing similar wrong order. Article 14 is not meant to perpetrate illegality or irregularity. If there has been a benefit or advantage conferred on or on a set of people by any authority or by the court without legal basis or justification, other person could not claim as a matter of right the benefit. Meaning thereby, my lord, if Tarun Kumar presupposes that an order which gives benefit is illegal. Now, my lord, this order at page number 48, my lord, whether they can, my lord, they can agitate the they can agitate the legality or illegality of this order before this court, my lord.
Just a minute.
My lord. Till 50 PM left. Now,
Nothing is there. In this evidence, tell us.
Whatever I
See,
place.
we'll have a satisfaction. Forget about parity.
No, Lordship. This is my humble submission. Ultimately, Lordship has to consider. And once submission has been made that we have wrongly cited some judgment, who are the petitioner to suggest?
Not wrong. What is not proper? He's saying not wrong judgment. It is a judgment, maybe not relevant.
It may not.
That may be his
Your
submission.
Lordship may not accept.
No, that is.
But I have every right to submit.
No. Definitely. According to you, there may be a judgment which is relevant.
Yes, Lordship.
For him, a judgment may be
May
relevant.
not-
Ultimately, we'll decide
Yes,
whether
Lordship has
it
to
is-
decide.
Yes.
But the petitioner, how the petitioner can make such type of submission?
That should not be.
No.
He is so excited.
No,
my lord, but now, my lord, here there is one more significant difference between Torun Kumar and other cases. Torun Kumar, my lord, will kindly appreciate is on PML Act. And in PML Act,
What Torun Kumar?
Torun
Torun Kumar says parity. We are not even going on parity. Is it your argument that parity?
No, my lord, because
Parity is law is well settled. What is your role?
Yes.
What is your role? What is the material? That's why you are going through it and you are arguing on parity.
And Lordship has to decide.
We'll see. Even see, there may be additional evidence. At that point of time, there was one witness.
Yes, now.
When others were granted. Now there are two witnesses. Suppose these two witnesses deposed against you and there are materials.
Yes,
Then will parity come?
If the roles are different, my lord, better.
Forget about the roles. Role in the affair and role and the deposition different. Therefore, we have seen these three witnesses. These three witnesses also only implications is that the specific is that we have not even charged him. So we'll have to record all these. And you are arguing in high pitch, what not? Make your speech slow.
And whenever we make objection, only but my learned friends become curious and he started defending us in outside the court.
This is not
This
the
is
way.
not proper.
This is not- We'll see. Therefore, I am going through the record. We'll have to do our judicial duty.
And
It's not that.
every counsel has duty to appraise the facts of the court.
Yes.
And some advocates are take it personally, lordship.
It's not case of personal. Therefore, we are growing into. That's why I have asked him. These are the evidences. So in this case, can we? We'll have to record what evidence is there subsequently.
Yes,
Had there been any material, we could have rejected. We'll pass this order. But not before Monday, huh? We'll get it on Monday only. Yes.
Condition lordship, order dated 18th lordship. And 2nd of February 24.
Anything, Mr. Borpujari, updated?
Yes, my lord, it is at the stage of my lord, the final, my lord, clearance.
What was the direction?
Direction was to, my lord, it was a consensus, it was a consensus order. He is entitled to, my lord, if my lord.
Ex post confirmation.
Yes, ex post facto confirmation.
How much time will you require?
Because in the meantime, my lord, the file was moved to the finance department. Now it has come back. I am appearing for the sole respondent, who is the Inspector General, under whom, my lord, he had worked.
Okay, now how you propose us? Let us take it as a consensus order. Let us wait for something. You tell us a date.
Yes, Lordship.
After 4 weeks, 3 weeks.
Lordship will kindly accommodate me for 3 weeks.
3 weeks. We are accommodating me for 4 weeks, but with an observation that Mr. Barpuz will apprise as regards the status of implementation on the next day. Okay?
18 same.
Now what to do? We'll draw a contempt, let him file an affidavit. Do you want that?
No.
Then let there be a hearing.
Lordship, if
All litigations are not
No,
adversarial.
lordship, if your lordship see their affidavit, lordship, what stand has been taken, lordship?
Okay,
I'm
you
not going to
contempt, you argue.
Lordship, no, lordship, I'm
Then-
not arguing, lordship.
Then
The conduct, lordship.
Mr. Borpujari submits that the order in question can be implemented and complied with within a period of 4 weeks from today. 4 weeks from today, in as much as it is in the advanced stage of compliance.
It is almost at the final stage, Lordship will record it.
Accordingly, matter stands adjourned and be listed on after 4 is given date. On which date Mr. Borpuri shall apprise as regards status of implementation. Apprise this course as regards status.
I am pursuing it, my lord.
Yes.
He need not worry. I am so blessed.
Yes.
Your lordship, they filed a
You want to,
application for
you are- yes.
vacating the stay.
Yes.
But your lordship, court has stayed the
Not vacating,
E5,
madam.
E4 to E5 and E5
So
to
tell us,
E6.
they have filed an IA.
IA.
Do you want to respond to it
Yes, yes. We have
or
filed
we'll proceed today?
we have filed a reply also.
Okay.
To that application.
Now, where is the interim order?
Interim order, your lordship will find.
In my application,
in the
my lord,
application.
page 22, in my
Huh?
application,
22.
Page
22. Third is Dr. Lana Senior Counsel. Issue notice, let the matter again. In the meantime, the result of DPC for promotion from E5 to E6 and E4 to E5 shall not be declared.
Why?
Because your lordship,
That is what I am
the
motivated.
DPCs which we have challenged, right from the year 2015 till date, everywhere your lordship will find the promotion has been given to my juniors with retrospective effect. So let them show a rule which says that that retrospective promotion can be given. This has affected my right, and accordingly, I have.
Where is the impugn order?
Impugn DPCs your lordship will find in the read petition.
Yes, where is that?
Was DPC 2015 is
Yes.
at page 45. 45. Yes. Now, may I read your lordship? Your lordship first will note at the right hand side, the date is 6/2/2016.
Page 43.
Page 45.
45, yes.
45, Annexure 3.
Annexure 3.
Yes.
Employee number, name. Discipline.
Yes. Employees-
Discipline.
Yes.
Where is the name of the respondents?
Respondent 3 and respondent 4 and 5 are here. Imdadul Haq Chaudhary and
Serial
Satan-
number 3.
Yes, serial number 3 and 8.
8, okay.
Then 2016 DPC. Again, your lordship will find at page 104.
But how do you respond that this is a promotion or DPC of 2016? You have not challenged it in time. The Constitution bench has said maximum 1 year. Settled position cannot be unsettled.
But we have filed this also. We have submitted a advocate's notice to them.
No, that is fine, but until and unless you challenge it. Now, what is the last challenge?
Last challenge is DPC 2022
Where is that?
or 24.
So in the meantime, they have become junior to you, senior to you.
All have become senior to me.
And if you do not challenge a seniority within a period of 1 year or promotion, that becomes stale. Constitution bench says that
But the fact also remains that all of them have been given retrospective promotion.
maybe, but you have not challenged. What is the judgment?
The judgment have not given.
Okay, we'll take up next week. We
What have I- that
will take up the interim next week.
on date may be given, my.
Give a date.
Yes. Thursday.
Huh?
Thursday.
Thursday. But so far that I forgot the judgment where it says that so far relating to promotion and service matter, the approach should be within a 1 year, and court should not impose judicial review, maybe illegality, unsettle the settled position. So in the meantime, from 2015, they have become senior to you. Now we'll have to reverse up to 2015, even there is illegality. This is a tentative view. I'm not saying. As agreed to by the learned counsel for the petition, ayat likhiba, parties list this matter on
26, my lord.
on 26th.
Obliged.
That's you be ready with that. He will show that, but though he is not ready with
No, I'm not ready, but I know, but
knowing and know
Well,
everybody knows, but you need the specific judgment.
Retrospective effect judgments I have with me. If your lordship was.
That is against you, is not it? Yes.